Okay. Hello, good afternoon. So for my portion, this will be a quick crash course on the regulatory issuances, the law and regulations applicable to the various types of digital assets in the Philippines. So this answers the following question. So if you're an issuer or if you're a company, not just limited to like blockchain empowered entities, but if you're a company that wants to implement, let's say, a new type of payment method, or you want to go cashless, and then the next questions you'd ask yourself would be, what's the applicable regulation for this activity, for the payment implementation that I want to do? What are the licenses or permits required? And which regulator would have jurisdiction over my activity? So uh, unlike certain industries, the regulation for figuring out what type of regulation would apply to your digital asset is not a straightforward manner. So depending on the functionalities that you want to introduce, digital assets could be characterized by a regulator as either a virtual currency, as electronic money, as security, or even as gift checks. And then, of course, this is continually evolving given how novel and innovative the subject technology is. There are still draft guidelines being issued by various regulators, particularly or most relevant for this case, the BSP and the Securities and Exchange Commission. So if you're an issuer, you have to be able to identify and enumerate the functionalities that are embedded in your token or in your system. So this table outlines the main types of regulations that would be important. So if you're a virtual currency, you would fall under the BSP. However, the BSP mainly regulates the exchange, where various virtual currencies are exchanged for other types of VCs or for fiat and vice versa. If you're an electronic money, you would still fall under the BSP. And the entity being regulated here would be the issuer, the entity issuing the electronic money. And then if, let's say it's a utility token, it may qualify as a security and therefore fall under the jurisdiction of the SEC. Now, the SEC regulates the security itself. So the token itself must be registered. And then the SEC also regulates the entities that can distribute or offer for sale the subject token, as well as the exchange or platform where the tokens would be traded. Now, if let's say you're merely providing a gift check, given the limitations in the digital assets functionality, then you don't need to get a license. However, you will be governed by the regulations for gift checks provided by the PTI. All right. So just a quick run through the various types of digital assets and how to determine what your digital asset is in terms of determining what regulation would apply. So for virtual currencies, this is a digital unit used as a medium of exchange, created by agreement within the community of VC users. So it's important to note that VCs under the BSP rules are not guaranteed by any jurisdiction and do not have legal tender status. Now, if it does have legal tender status, it may fall under e-money instead. Now, electronic money, it's stored in an instrument or device. So it could be cash cards, it could be in your mobile device, and then issued against a receipt of funds, and for not lesser in value than the monetary value issued. And then this is an important part of the definition. The asset or the e-money is accepted as a means of payment by persons or entities other than the issuer. And lastly, the token is withdrawable in cash or cash equivalent. Usually between an e-money or a VC and between an e-money or a gift check, the difference usually lies in the last two requirements here, letter C and D, that the token, the asset, is accepted as a means of payment by entities other than the issuer, and it's withdrawable in cash or cash equivalent. Usually or generally, if it doesn't if the asset doesn't have this two or doesn't meet these two requirements or these two definitions, it could very well fall under the meaning of gift check. Now, to illustrate, let's say you're a retailer or you have a platform and you want to introduce a new cashless way for payments. And then if the token itself, the digital asset that you will issue may only be used by users in your platform, and there won't be any P2P transfers, and the users or the holders of the tokens won't be able to withdraw the store of value. In most cases, that could just be a gift check. However, once you introduce a functionality that would let them withdraw the store of value for cash, for pesos, then you might fall under e-money. Okay. Now, let's go to gift checks. So as I said, a gift check is any instrument honored upon presentation at a single merchant or an affiliate group of merchants as payment for consumer goods or services. So it may be in the form of paper, card, code, or any other device. So now, in the example I stated, it's important to know what functionality would trigger what regulation, just so that you're aware whether your activity is already stepping into an area of the regulations wherein you'd have to get a license with the BSP or maybe the SEC if your token would have any characteristic that would render it as a security. So the obvious examples for gift checks would be, let's say, a coffee shop that allows you to purchase gift cards or allows you to load up your mobile gift card so that you can use that store of value for payment only in their participating stores or branches. Now, in that case, that's a gift card. Now, if let's say the coffee shop suddenly introduces a functionality that would let you withdraw your store of value for cash, now they may be considered as EMI. Now, for securities, securities are any token or digital asset that would represent shares or participations or interest in a corporation or a commercial enterprise or some profit-making venture. It's evidenced by a certificate or contract or any other instrument, whether written or electronic in character. Now, as I said, the digital asset that you would be issuing or you would be trading could start out as one thing, but once it undergoes certain developments or you change its functionalities and its purposes, then you might cross over to another regulatory area. So now another relevant regulation would be the regulations issued by the CEZA, Cagayan Economic Zone Authority, which regulates virtual currency exchanges in the zone or in CEZA alone. So this is relevant for virtual currency exchanges or any entity, usually foreign, that would want to be regulated by a government authority. They can go to CEZA and apply for a license there. However, it must be noted that for an applicant to be qualified under the CEZA rules and thus operate in the zone, its target market or its users must purely be users offshore. So CEZA-based entities can't target Filipinos. Once they do that, then the previous regulations which we've discussed would apply. All right, now. So moving forward, there are various regulations being drafted right now, as mentioned. However, two of the most relevant ones would be the SEC rules on ICOs, on initial coin offerings, and the BSP's draft rules for virtual assets and virtual asset providers. Now, for the SEC rules on ICO, it basically provides the procedure which must be followed by token issuers before they issue the tokens to the public. So the SEC, based on the draft, they want all issuers to submit for an initial assessment with the SEC, submit their proposed tokens, submit their white papers. And then based on that, the SEC will do an initial assessment and review whether the token is a security token or not. If it does determine that it's a security, then the token must be registered with the SEC as per its securities rules. Now, aside from that, since what's being contemplated here is a digital token, the SEC also requires that they conduct an ocular inspection as well as a system walkthrough. Now, again, this is just a draft. It hasn't been approved yet. Now, for the BSP, it issued its draft guidelines for virtual asset providers. And then based on the guidelines, the regulator basically broadened the scope of what could constitute as a virtual asset. And it also broadens the scope of entities which the BSP regulates. Now, it's important to note that under the existing regulations for virtual currencies, the BSP only regulates the exchange itself. So it doesn't regulate the issuer or the other service providers whose services are necessary in order for the exchange to happen. However, under the draft guidelines, the BSP now regulates the entities involved in the exchange of the virtual assets, as well as those which conduct the safekeeping and or administration of the virtual assets and instruments, as well as service providers that provide just the technology that would make the exchange possible. So that's basically where we are in terms of the regulatory landscape for digital assets. Now, I believe the next two speakers would do a more in-depth dive into the existing regulations for blockchain, as well as the operations, or what happens what you refer to when you say blockchain implementation, etc. Right now, I'll pass it on to Attorney JJ.